We're very pleased to have Professor Helena Hofmannová. I'm saying this Polish style, so I don't know how. You can probably put the accent on a different syllable. Who's an associate professor of constitutional law at Charles University in Prague, as well as an advisor to the judge of the Constitutional Court of the Czech Republic. Very interesting. We have probably questions about the Constitutional Court, given what's happening in Poland with that court. After the fall of communism, she's been a pioneer researcher in the field of the legal and social positions of Jewish minorities in the Czech Republic. And recently, in light of the threats to liberal democracy, she has written on human rights protection and democratic theory, with a special focus on Europe. Between 2012 and 2014, she was a member of the advisory committee of the Framework Convention on the Protection of National Minorities. In 2018, she was appointed to the Council of Europe's European Commission Against Racism and Intolerance. And she is, of course, the author and co-author of several books, as well as a number of articles. And she's at the University of Michigan this year. She's visiting scholar at the law school. The law school is also co-sponsoring this lecture. We're very happy to have these overlapping co-sponsorships. So please join me in welcoming Professor Hofmannová.
Good afternoon. Thank you very much for introduction, and thank you very much for the invitation. And it's an honor for me to be here presenting my lecture. The issue of national minorities is currently in the background of the main European affairs. It is behind especially the so-called migration crisis, which became a test of sharing of European liberal values. And it is also in the background of the, I would say, of the current challenges of the European political regimes struggling with the resuscitated complex of the national enlightenment. In my lecture, I want to show that if we approach the issue of national minorities from the so-called flexible or open approach, this issue is also a problem of migration crisis and also European democracy. And the issue of minorities, however, relevant also to the classical categories of democracy. And this is because the democracy, or the essence of democracy as a rule of people, depends on how we define the people who exercise the public power in a concrete state. But the issue of minority is important also from very simple and essential point of view. And this is that the history repeatedly shown that the way we treat our national minorities is directly connected with the success of democracy and with the character of political regime. So, I divided my lecture into three main parts. In first part, I will briefly, I promise, briefly deal with the main historical facts which directly influence the constitutional and political development in the Czechoslovakia and the Czech Republic. The second part will be devoted to the current status of national minorities in the Czech Republic. And finally, I will provide an analysis of the interpretation of the Framework Convention on the Protection of National Minorities and outline the gap between the universal and national approach to the protection of minorities. I think it's also good to mention that this year the system of the protection of national minorities celebrates its 100th birthday from its foundation after the World War I. And the first question is whether a system which has been around for a century is still applicable without any serious changes to the contemporary world. And just like the minority protection system celebrates its 100th birthday, so does the gap between the universal and national or domestic approach to the protection of minorities. And I can say honestly, there is not much to be celebrated. because the gap between these two approaches, these two concepts, I mean national and universal, is getting even much deeper with the rebirth of nationalistic and cultural stereotypes across the Europe. Moreover, the post-communistic country as the Czech Republic, they that oppose the accepting of new minorities within the migration crisis, they feel as a new minorities within the European Union themselves. And this notion was directly expressed by the Parliament of the Czech Republic in its statement to the activation of Article 7 of Treaty of European Union against Hungary. In this statement, the Parliament of the Czech Republic declared that the voting of the European Parliament against Hungary was wrong, and, I quote, "This process is just going to deepen trenches and mistrust between the old and new member states." So all these facts raise a question: to what extent does these national complexes, I can call it complexes, influence the current nationalistic and separation ambitions in Europe? I do not want to go into many historical details here, but the main minority status has had such important influence to the overall constitutional and political development on the overall our history. This influence is reminiscent to a well-known psychological axiom. I don't know if you know this, but according to what if someone doesn't resolve the relationship with his or her parents, he or she is unable to establish a functional family themselves. And Czech Republic is a patient of such kind, literally. The minority status, as many of you probably knows, played, therefore I am not going to go into really like details, I try to make some overall. So the minority status played a crucial, very crucial role in the very birth of Czechoslovakia in 1918. It was one of the reasons for creating a fiction of Czechoslovak nation as a new sovereign, constitutional sovereign, and which was created by the union of Czechs and Slovaks. And the underline of that reason was very pragmatic, because the Germans were the second biggest group in the territory of the Czechoslovakia at this age. At this time, the new European borders set out in Versailles Treaty gave the Czechoslovaks the territory which they fought for, the state territory they fought for. But along this came minorities, a lot of them, and the international commitments which they didn't ask for. And on such roots, the Czechoslovakia, and this is very important, was founded not as a national state of Czechs and Slovaks, but literally as a multinational state which treated all citizens equally, regardless any criteria. Plus, the new Czechoslovak constitution incorporated a part with the special protection, special protection for national, language, and ethnic or religious minorities. These principles, incorporated by peace treaties to the Czechoslovak law, established the ground for the legal position of the minorities in the Czechoslovakia and later the Czech Republic. But the normative content that came with this system originated internal and external tension, which is still present to minority law of today. On this tension, in my opinion, is the fact that on one hand, the minority protection is based on the principle of equality regardless any criteria. But on the second hand, and on the same time, it's also based on the affiliation of its member to some particular group which is different, which differs from original majority. And only members of such groups are entitled to enjoy all minority rights. But in fact, the normativity of this minority system during the interwar period was totally overwritten by the facticity of problems. So I promise that I will make it briefly, I mean, this historical part. So I just can say that during the interwar period, the Czechoslovaks perhaps gone through all possible variants in regards to minority. The minorities became majority to become minority again. The tolerance, multinationalism, as well as national homogeneity took place in the territory of the Czechoslovakia, and minority assimilation, discrimination and segregation, including confiscation of property and displacement of people, have taken place in Czechoslovakia from the World War I till the World War II, I can say. During the communistic period, it was different. During the communistic period or communistic regime, I can sum that the issue of minority was de facto ignored and formally controlled by the central power of the communistic party. The legal status of minority I described in the beginning has not been restored after the World War II. A new one has not been adopted. According to the first post-war constitution of 1948, Czechoslovakia was a national state deprived of all kinds of hostile elements. Not even the next constitution of 1960 guaranteed the status or protection of minorities. According to its preamble, there was new constitutional sovereign, and it was the working people of Czechoslovakia. So the belonging to minority, to national, excuse me, when I use term minorities without national, I mean minorities, like national minorities. So the belonging to minorities was like absorbed, totally absorbed by the belonging to ideology. The first new legal regulation in Czechoslovakia came with the birth of Czechoslovak Federation in 1968. But very shortly after this, during a time of so-called normalization, minority rights set out in this constitutional law on the federation, as well as all other human rights, became like mere declaration. The homogeneous political structure under the communistic or socialistic regime has limited the openness toward the other individual identity, and also exercise the pressure against identities contradicting the overall communistic ideology. The diversity was and still is limited only to a traditional living groups of national, ethnic, or religious minorities. And what is important, that all these phenomena strongly influence the attitude towards minorities and their position in the Czechoslovakia and later in the Czech Republic, also after the fall of communism. So the change came in 1991 when new constitutional legislation was adopted in the Charter of Fundamental Rights of Freedoms. It was even before the Constitution. Charter of Fundamental Rights and Freedoms, which is still part of the constitutional order of the Czech Republic. The charter was adopted during a time of federation by the federal parliament, but after the dissolution of federation, it became valid in both states. In Slovakia, it's a part just included in the constitution, and in the Czech Republic, it's a like separate constitutional document, like a catalog of human rights, because there were big discussions concerning the applicability of human rights. So it became like a separate part, but it's a part of constitutional order of the Czech Republic. So, and for the first time of the Czechoslovak history, the charter introduced the character of, or the concept of human rights as a nature right. The first Czech constitution, it was like positive conception, the first time, nature right conception. But otherwise, the protection of minorities is based on the very similar criteria like the first Czechoslovak constitution. The fundamental principle for the whole charter is the principle of equality in dignity and rights, together with the prohibition of discrimination. And besides this general principle, which apply to all people without any distinction, the charter also incorporate special part on the rights of the national and ethnical minorities. The purpose of this right, I'm not going to list all these rights, this is classical minority rights, but the purpose of these rights is both to preserve and develop their identities and participation of minorities in public life. The other break moment was the foundation of the dissolution of federation and foundation of the independent Czech state, independent Czech Republic. And after the creation of the Czech Republic in 1993, the question of creation some like national, domestic minority policy emerged. On Czech side, there were a lot of publicists stressed the national homogeneity after this long time of communistic regime of Czech nation, and also they stressed like the new dimension of ethnically pure Czech nation. But it must be said that at this time of its establishment, the Czech Republic was indeed a national homogeneity state. And however, the law on minorities, was adopted up to 10 years after the charter, after the acceptance of charter. So it means in 2001. So it was the long time of preparation of law affected very strongly his character. Because while in 90s, the question of recognition of national minorities and different identities was crucial for the new state. At the time of the adoption, the law, the situation changed fundamentally. And not even the law, but also its interpretation doesn't respond flexibly to this change. The act introduced first time in the Czech Republic, and this is something special because this is not usual also in the international law to have these definitions, but the Czech law introduced the definition of the national minority and also the definition of the person belonging to a national minority. Under this law, minority or a member, this is the same criteria, or a member of minority must fulfill about 5 criteria to be recognized as a minority. So the members of minorities must be citizens, this is first condition of the Czech Republic. They must live permanently in the territory of the Czech Republic. They must differ from other citizens by their common origin, language, race, or tradition. They must present a numerical minority, and at the same time, they must show their will to be considered as a minority or as a members of national minority for the purpose to preserve and develop their culture. And so what's the definition of minority in the Czech law looks like? And in addition to this definition, the Minority Act introduced also new category of minorities traditionally or for a long time living in the territory of Czechoslovakia. And what is important, only this type of so-called traditional minorities and its members are entitled to enjoy all minority rights. All these criteria I mentioned, all these criteria set out in the Czech law are absolutely controversial from contemporary minority protection, including the very existence of the definition of a national minority. In other words, Czech legislation represents typical example of traditional or conservative approach to the protection of minorities. But maybe it's appropriate to add at this moment that Czech Republic is not only a state like this, that there are many European states, members of Council of Europe, who has the same or very similar criteria like Germany, Austria, Denmark, or Hungary, for example. The problem is that the common understanding of the protection and status of national minorities and what it entails has rapidly changed over the last 2 decades. This change we can identify from the interpretation of the Framework Convention on the protection of national minorities from 1995, which is the only legally binding international instruments on the rights of people belonging to national and also ethnic minorities. It's very interesting to study the preparatory work. You know, in 90s it was very, very tough time, and the preparatory work gave us a very, very deep knowledge about the sense of international minority protection. But yet the very preparatory work indicate that the Framework Convention was deliberately already at this time conceived as a so-called living and dynamic instrument. We can also see this from the commentary on the convention. The commentary on the convention explains that the convention is to be interpreted and applied dynamically as a living instrument, fully incorporating current and future development and changes in understanding of minority rights. I would say that this approach is really one of the most important attributes of the convention, and also it's fully in line with the dynamic interpretation developed by the European Court of Human Rights. But at the same time, it's the most difficult goal to achieve. But the importance of the interpretation of the Framework Convention is reinforced also by the fact, or by the character of the Framework Convention. It means the Framework Convention, this is the title of the convention, means that the convention contains mostly of program type provisions which are not directly applicable and have to be implemented by the means of domestic legislation. But on the other hand, states are under the legally binding obligations to ensure the compatibility of the convention with their domestic legislation and also practice. But, you know, the very important question is how should we define this so-called dynamic or flexible interpretation so it becomes more than just an empty phrase? And I think I can briefly, because I was a member of advisory committee and we were negotiated a long time and a lot of meetings about this. So I think I can briefly capture this in two principles. First principle is that the convention, the framework convention, rather than asking who should be protected, asks what should be protected to ensure diversity through minority rights. And the second principle is well-known article by article approach. I don't know if you heard about this sort of interpretation, an application and implementation of the convention, which means that the framework or the scope of application of the framework convention must be established for each right separately. It means that some rights must be extended, like equality, tolerance, and other, to all members and all minorities, while some other rights could be limited only to some kind of minorities. And accordingly to these two principles which I described, the Council of Europe has been highlighting for a long time in its documents and declaration and resolution that the Framework Convention addresses societies as a whole, not individuals or some specific groups. And also for that reason, the convention doesn't contain the definition of the term of national minorities. This absence of definition of the term of national minorities leads very often to the superficial conclusion of states that the application of the convention is solely left to the arbitration or to the discretion of state parties. But such conclusion is incorrect and it runs after the Article 26 of Vienna Convention on the Law of Treaties and the principle Pacta sunt servanda, because also the commentary makes it clear that the absence of definition is not only intentional, but also like a necessary to ensure that all specific circumstances of states, including societal, economic, demographical circumstances, are considered when establishing the applicability of the minority rights. And this narrow connection of minority protection with the societal and political development is also, in my opinion, one of the most important reasons for justification for this dynamic interpretation of the convention. As I already mentioned, the common understanding in the international law of minority protection and minority status has really fundamentally changed during the last 2 decades. In the time of negotiating the convention, I mean in the time of after the fall of communism, for example, the breakup of Yugoslavia resulted in various armed conflicts, which were mostly often because of instrumentalization of ethnicity. The dissolution of Soviet Union resulted in a various armed conflict in Central Asia. Even the peaceful dissolution of Czechoslovak Federation worsened the relation between the Hungary and Slovakia on the issue of Hungarian minority in Slovakia, and there were increasing disputes between Hungary and Romania. And this is just example of such conflicts. And all these conflicts and tensions were the result of ethnically based friction between nationalistic groups. So therefore, at the time of the adoption of the convention in 1995, the protection of minority rights was mainly associated with the preservation of minority identities and with the protection from their assimilation within this state formation and national building process, which was violent in a lot of cases. But since then, I'm trying to be brief because I'm sure you know about this development, but since then, the increasing global mobility of population transformed Europe. and the focus of international protection or international or human rights organization shifted, especially to the challenge on forming like open and inclusive society, and to the fight with radicalization, which is widespread in a number of European countries. And as you know, the present day European context is very significantly currently marked by the migration movements of unprecedented scale, and this coupled with the recurrent economic crisis and with the increasing so-called security issues, it destabilizes societies and alters the way how the minorities are perceived, but not only by society or majorities, but also by policymakers. And this process significantly influenced the international minority protection. And this is one of the reasons, this development, because maybe I should just add that during this development, the gap I spoke about between the international and universal approach and domestic approach even deepened. And this was one of the reasons why the advisory committee in 2016, so it's pretty new material, adopted a very special commentary on the scope of application of the Framework Convention. And this is the first commentary who expressed the guidelines and priorities of the international or European minority protection. I can say now that all these criteria set out in the Czech law are listed in this commentary as not even controversial, as discriminatory and exclusionary. When I return briefly to this criteria, we can make very short comparison. You know, the first is the very definition of minority, because not only the commentary, but also the Council of Europe and other international human rights organizations constantly stress that the convention, not only the Framework Convention, that the minority protection is not suited for any static definitions. The minority is interpreted as a social phenomena, not only as a legal term. So it's not suited for any static definition, and that especially the access to minority rights shouldn't therefore depend on any formal recognition. But also, all other criteria are inconsistent with this flexible or dynamic approach. The precondition of citizenship, which is applied not only in the Czech Republic, but almost in all European countries, member state parties of the Framework Convention, and we are very criticized for this criterion, is because it's consistently considered as a restrictive requirement with discriminatory effect. Because, you know, a number of people in Europe, or number of persons belonging to national minorities, lost their citizenship or even become stateless due to the creation of new states. Even they have long-lasting ties to their places of residence. And the international organization constantly underline or stress that it should be considered for each right separately, whether there are legitimate grounds to differentiate based on citizenship. Even the Czech law further refers to the length of residency, or respectively to these traditionally and long-time living minorities. Also in this regard, the commentary says or stresses that the length of residency is irrelevant, it shall be irrelevant in the terms of applicability of minority rights. Obviously, the differences between the traditional minorities and other minorities leading to the reduced access to minority rights is criticized too. So this is all these criteria are considered, I can sum up that all these criteria are considered controversial because they can result, and they are in practice resulting, in arbitrary denial of minority rights. But now, you can ask, or now we have a question, what are the legitimate criteria for which advisory committee for the Framework Convention or other international minority or human rights organization considered for minority protection? And this is a very difficult question. Actually, there are not many such criteria. There is just one. And this is the only criteria which is considered as legitimate. This is the principle of free, or the right of free self-identification, as the right of individuals to decide whether they wish to be treated as a member, as a belonging to some national minorities, and also if they wish to be treated or to be protected by minority rights. And this principle, together with the article by article approach, they are cornerstones of the contemporary international minority protection. But another problem, there are more problems, but I am trying to point out the most important. So another problem is the question why this system doesn't work. Why has the dynamic and open interpretation has been failing not only in Czech Republic, but in almost all European countries? And in sort of conclusion, I will try, maybe for discussion also, to provide with some possible reasons why it doesn't work, this flexible interpretation, and also, of course, application of the Framework Convention. In my opinion, one of the reasons is this inner dichotomy. I was looking for the word in English vocabulary because it's not so used, so we can say dichotomy, which is of the minority law, which I described in the beginning. From the point of view of the international human rights protection, it's embodied in the tension between the universal approach, which is based on principle of equality of all people, for all people, and I call it community principle, as a ground for self-identification, for belonging to some national minority. And they are required at the same time. And in domestic legislation, there is another tension between otherness, because they must differ, but sameness, because they must be loyal citizens, required at the same time as a precondition for recognition of minority status and protection. And these legal issues, briefly said, these legal issues also reflect perpetual conflict and tensions between the nationalism and pluralism, which is going through kind of new age in current Europe. But another problem is, I need to be critical also to the Framework Convention, because another problem is the conception of the Framework Convention itself. Because the implementation of the principle of self-identification is very complex. It's very, very complicated. And it can be illustrated on the question how to protect those who cannot be legitimately or even legally considered as members of protected group, because they are, for example, from absolutely reasonable reasons, are afraid to sign up with appellation with some minority. But the reaction, for example, very current reaction of our president to Roma is they do not serve any protection because they are just not willing to show their will to affiliate with their nationality. So the only way how this is realized, I mean how it's realized the principle of free self-identification is dealing with concrete situation in concrete states. But this procedure raises another question, and this is the potential of the control mechanism of the Framework Convention, because the advisory committee as the maybe the main monitoring body for the implementation of the convention, so its competence is to monitor rather than to enforce, of course. And the results of this monitoring process of implementation of the convention, the so-called opinions of the advisory committee, they are not only not respected by almost all member states of the convention, but the states just do not pay any attention to these opinions. So consequently, the opinions of the advisory committee, as well as the resolutions of the Committee of Ministers of the Council of Europe, they lose any impact to the real problems due to the constant repetition of the same problems. And I am witness of this process, so I can tell that it's really like this. An important role, and I'm almost in the conclusion. So an important role is, in my opinion, also played by fact that the issue of protection of the minorities is in many cases understood as a political issue. And it plays a very crucial role on the system of protection of minorities. And not only by, and what is important, not only by policymakers, domestic policymakers, but also from the international organization themselves. Also, currently, the protection of minorities is understood not as a human rights issue, but as a security issue. And this, I mean, the lack of competencies, together with this evasive approach of the international organization, make the controlling mechanism like a toothless mechanism. And maybe finally, let me say just that, I shall say finally that, however, the main problem of the minority protection in the Czech Republic, and I mean in all Europe, is however not the issue or the status of the traditional national minority, because all these reports of international organization, including advisory committee, points or constantly underlines the danger of xenophobia and nationalism widespread across a lot of European countries. In many countries, new forms of even economic nationalism, are emerging, and there are tensions not only among majorities and minorities, but among new, so-called new or other minorities and traditional minorities. And politicians across, now it's not just the issue of some right-wing parties, but politicians across the political spectrum, they do not find these phenomena, but instead of them, they use them as an excellent political artifact. Especially nationalism proved to be invaluable in the terms of gaining political power. I think that nationalism and contemporary nationalism in Czech Republic, Poland, and other countries is so attractive because no matter the individual characteristics people in its nation have, it will give the value people just because they belong to nation. And this is very attractive for a lot of people. And today, I think when we can take it as a historically proven fact that nationalism is always in political practice associated with authoritative or even totalitarian ambitions. So it's our sort of failure that we are not able to analyze why people is still willing to sacrifice their freedom and dignity. So this is, in case, just I am not sure about timing and discussion, but in case I disappointed those who expected me to speak about more like specific problems in the Czech Republic, I prepared some more information so I can share. But I am not sure about.
We do have time.
I'm perfect on time.
Yes. Thank you so much. We're very happy to have this at once broad overview, but also with very specific details about the situation, the legal status of minorities. And now we have we have until 1:20 for discussion of these issues. And there's a microphone in the room, embedded in the ceiling.
So
actually,
no.
No, we don't need to circulate a microphone, but we ask that you speak loudly enough for the recording, because the lecture is being recorded.
Oh, yes.
So I will leave it to you to actually call on people.
Okay, maybe if I can, or if you wish, I have this, I can maybe make some I have some more information about the minority composition, which is pretty interesting. So I can start with this, and then if you are interested in some issue concerning the first part on this, I just feel little. I couldn't decide how to take the lecture, how you describe this overall, or some concrete problems. So maybe it can be interesting for you that in the Czech Republic we have 14 legally recognized minorities, which is pretty much, but almost all of them are traditional minorities living in the territory from its foundation or a little bit later. Listed, and this is interesting, listed by size from census. The biggest minority is obviously Slovaks, then Ukrainian, they are the second biggest, Polish, the fourth, which is surprising, and these numbers are lower than estimates, of course. The fourth are Vietnamese, which were recognized because they are traditionally living in the territory of the Czechoslovakia and the Czech Republic. Then Germans, they are going lower. Russians, Hungarians, Roma, and then we start with small size minorities like Bulgarian, Greek. We have Greek minority, Belarus, Serbian, Croatian, and small group of Ruteninian people from also living traditionally in our territory. But when we are guided not by census, but by the estimates of the real situation, the biggest minority is Roma. And this is something really very significant, because the number of Roma who declared their affiliation with Roma minority in census is about 5,000.
It's 15 now. 15,000.
15,000. Maybe 15,000. But the estimates, as you told me yesterday, is even bigger than I thought. It's about 500,000. So it's really very huge difference, So this is, I think, and because I want discussion, so just last maybe interesting issue is that, in my opinion, but maybe you will have another opinion, in terms of particular problems, or there are, I would say, just two minorities which are dealing with problems or are problematic. And in my opinion, it's of course Roma, because it's a long-lasting, serious social problem. But the second minority now, and maybe surprisingly, is Russian minority in the Czech Republic, is dealing with a very big political division inside of this minority. There is a very influential part of Russian minority, cooperated with right-wing parties and xenophobic parties, and organizes seminars in parliaments, and they are making conflicts not only inside the minority, but also they negatively influence all this democratic environment towards minorities. So, but maybe I could speak more and more, but maybe I stop, and if you have any questions, I would be more than happy to try to answer you.
I'm sure there will be many.
Oh yeah. Thank you.
Oh yeah.
Happy to.
No, go ahead.
So,
I'll be later.
so I was just, first of all, thanks. It was fascinating talk. I was just wondering whether there might be two things running together here in terms of minority protections and how those are being thought about. And what I mean is that if you look at Canadian literature, where it comes out most, Americans actually don't really think about this that much.
That's right.
So we distinguish between ethnic and cultural diversity and national minorities. And there is actually a definition, Will Kimlicka and others talk about this, that the national minority is different because it conceives of itself as having a political dimension to it, that they strive to have some form of political self-determination. And that's different from being African American, Jewish, of Korean descent, whatever, you name it in the US. None of us thinks of ourselves as belonging to something that we actually want to have a political self-determination. That is a distinction between national minorities and ordinary other minorities. Now, if you start to think about that, you would say, well, now protections should actually be different for these different kinds of groups. And all of a sudden, citizenship actually makes some amount of sense when you say, well, if you're a national minority, but you're not a citizen, then you're just an occupied people. And you should have yet different sets of protections for that. So there actually are three sets of protections. One is for an occupied, a hostilely occupied people that does not view itself as being citizens of the overarching polity. Another set of protections is for a people that views itself as having a claim to political self-determination and yet shares citizenship in an overarching polity.
Right, yeah.
And the third is your run-of-the-mill ethnic, racial, whatever identity, separate identity that wants some minority protection. So those are sort of three different categories of protection. So does nobody sort of think about it in those terms? Or it sounds to me like those are all being mushed together in people's objections to what's going on in the Czech Republic and the convention. Do they just not think about this?
Yeah, no, I mean, this is a very good question, and I probably would speak more about this if I have more time, but you are absolutely right, and this mixture is maybe paradoxically made by the Framework Convention. They wish to mix, they wish to mix all the minorities together with migrants, and give them protection based on their wish. This is really sort of mixture, and this is also because on this, one of the pragmatic reasons is that in these monitoring bodies there are almost no lawyers. It's more like activists, and human rights people and journalists even. So there are few of them and they were before, for example, the acceptance of commentary. But this is a very good question. The Czech law, actually, we know even in the title of the part of Charter of Fundamental Rights and Values, we have national and ethnical minorities. The law doesn't repeat this. It's only about national minorities. Based on the Czech literature, authors and commentaries, the difference, and this you can correct me if you, it's that the national minority is something subjective. This is subjective criterion. Because you can choose, I am Jew, I am German, I am Czech, but I am from Greenland. And you also can choose no nationality. It's on your will. So this is now like the explanation of the term, but ethnical minority you cannot influence, it's objective criteria. Because you cannot change your color of skin, your, other physical features, you have some language, the origin of your parents. This is really the interpretation which you can find in Czech law. In international law, you find mostly they use it like synonym. They use it like synonym, national. When I try to explain in my mandate, for example, that census is not about ethnicity, but it's about nationality, they said, oh, yes, maybe some note. And again, in text, it's ethnicity, But this is very important. The other and very complicated issue, which is not too much really elaborated, it's the political aspect of the national minority. Because maybe the Germans for some time were the political national minority in the Czech Republic with some ambitions. Maybe sometimes Poles, now maybe the Russians, And also, therefore, why in Czech law, based on the explanatory report on the minority law in the Czech Republic, the division between the national and ethnical minority was because of Roma. Because Roma are not considered as a national minority, but as an ethnical minority. And the truth is that they have really very different claims and situation than, for example, German or Polish minority, because they do not ask for their language in schools, you know. They do not ask for bilingual signs. They ask to be tolerated, not to be discriminated, because they really deal with the significant now problems with the access of even education, healthcare service, housing. You know, they are living in the outskirts of the cities, and the main problem, and I have to say here, is the education, because you know, I don't know if you heard about the case DH versus Czech Republic. It was a disaster, but this case was decided by the European Court in 2006 or 7. So, and Czech Republic has not been executing this decision for more than 10 years. Last year, we introduced so-called inclusion. And excuse me, the case was about that the Czech Republic violated the European Convention on Human Rights because of putting disproportionate huge number of Roma. It was an automatical process. If you were Roma kids, you went to special school, so-called special schools, which are with limited. It's for handicapped. Actually, it's schools for handicapped kids.
Or with some problems with
small kind, yeah.
Learning.
the learning
Yes.
disabilities.
I'm sorry.
But
This
the
is my
problem-
colleague from. I will introduce
Yeah.
from Charles University. This is the dean of the law faculty of Charles University.
No,
But especially, he's the one of the really, without any like formal compliments, he's the one of the biggest specialists on the minority issue, having a lot of projects on minority issue, and also on the historical Jewish, German, Czech relationship, very detailed history and work. So he knows maybe more about this.
Not,
Yeah.
not
So
about
turn
this.
around
Yeah, but I'm not here as a dean. But but I think that to clarify this, I think that theoretically, then the Czech Republic could claim that those children were, of course, of Czech nationality, because theoretically,
course, yes.
of all their families, they during the census they say that we are
Yeah,
Czechs.
yeah.
You know, but of course the whole classrooms were, of course, only of children of Roma
Yeah.
origin. So this is a very good example about the fact and legal situation and what is in fact. So I think that this is one problem, and maybe there is another one which was mentioned, that there were minorities not only in Czech Republic but let's say in Central Europe, which were called, or which are still called, traditional minorities, like the German minority or Polish minority or
Vietnamese.
Hungarian minority in Central Europe. This is the case for Czech Republic, Slovakia, and this is usually also the question of relations with the mother state, with the neighboring state, because of course when you have the German minority, of course, a very different situation to have a 80 million Germany as a neighbor, or to have Hungary with and Slovakia, so the influence, of course, the relations. But then you have the new so-called new minorities. So
Yeah.
when we mentioned that we have 14 minorities, now majority of them are, of course, so-called new. It means that they origin after the Second World War, like Vietnamese minorities because of the Soviet bloc. There were the foreign workers, Ukrainian minority,
Yeah.
or we have even Greek minority because of the Cold War and things like that. You know, so it's even more complicated. That then to find one criteria for two different situations is also a problem in a situation which we will have in Czech Republic. And what you mentioned, if we put it together, it's even more difficult. And when you realize that what the state have as a tool to have a census, and you have this during census you are asked what nationality you are, and this is the only official information you can have.
It's only, yeah.
Yeah. Then this is really I think it's even more complicated to say who is a member of a national minority, who is a member of ethnic minority.
And just one more thing, just to clear, and legally, you have constitutional right to express or no express nationality in census. But in fact, the law is connected with the numbers. So if you are not associated with, if some region, for example, there are not so like 5 or 10 persons belonging to national minorities, because Roma are afraid to affiliate. So they cannot have some minority rights. So this is this tension, you know, which is ongoing for decades. And maybe the last thing, you know, we don't deal with I think, what do you think, that we do not deal with maybe Germans, it was with this political issue inside, like irredentistic or something. It's not now, but maybe the only political issue is the Roma, because it became a political issue, this case the age. And I just, you know, our president just recently absolutely strongly stress admire the duty of work they had during the communistic regime and physical treatment of Roma people, you know. And we have a lot of cases now of denial of Roma Holocaust during the Second World War but this is sometimes not only from the right wing of political spectrum, but also President of the Czech Republic stresses such. So this would be political, maybe also issue. I'm sorry.
We have one question, another one, and I have also.
Mine is actually related to Daniel's, though I came to it from a completely different direction. I mean, Daniel said that we don't have minorities that aspire to political organization and status in this country. In fact, we have hundreds, Indian tribes, which we all forget about.
Oh yeah, that's right.
And it was thinking about the Indian tribes, which I don't know anything about. Hardly any American lawyer, including constitutional lawyer, knows anything about the constitutional status of Indians, because it's extraordinarily complicated. But many of them are recognized as separate sovereign nations, although Indians also have American citizenship. It's very complicated. But what brought me to this was your remark that the one fundamental right is the right of self-identification. Now, in fact, in the case of Indians in America, that is very controversial. There are two kinds of questions that come up. One, there's groups that want to be legally recognized as tribes, and the Bureau of Indian Land Management or Indian Affairs is denying it. That's one kind of question. And another kind of question is there are people who want to be recognized as a member of the tribe, and the tribe says, sorry, you don't have enough of the relevant blood. And that can be very important to who gets to participate in the tribal councils and share in the revenue from casinos or whatever. So as I say, I'm worried about even this single fundamental right that you claim of
I agree.
self-identification.
I mean, I try to be critical to this because I think it's very naive also, and and I said that it's very, you know, it's very almost impossible to apply this self-identification. And you know, this is very similar problem we deal in Europe with Sami people from you know, Lapland, because Finland actually would be the example for the Framework Convention. Because I do not have quotation here, but if I remember, in Finnish constitution there is, even in the constitution, is that minorities are not depending on the governmental decision, but on their will to be recognized as minority. They have such constitutional provision, but they have very important part of country where are living these Sami people, and their status is close to Indians. And also they have problems. For example, they have their own parliament, with voting rights, but they do not even want to accept some Sami people, which claim they are Sami people, because they said, no, we don't think you are enough Sami. So this is also, but maybe from the point of view of international law, there would be considered as an indigenous people, not as a minority. This is another issue, very, very interesting, indigenous people. Because we in Europe, we still think, oh, they are in America, in Australia, this is not our issue, but it is. You know, for example, the Finland, and this is very crucial issue for the country. So, and yes.
Yeah, my question is indirectly related to the subject of your talk. So often discrimination on the basis of national origin or ethnicity goes hand in hand with discrimination of other minorities. So here in the US, there are protections for people who belong to national or ethnic minorities. But there's still a struggle about sexual minorities, for example. So I was wondering what the status is in the Czech Republic.
Oh yeah, in Czech Republic. Okay, now we have a big discussion in Parliament about the recognition of not like about the recognition of marriage, men and men, or one-sex marriage. But the issue is not to recognize the one-sex marriage, because we already have such form of recognition, legal recognition of such relationship, but about the title. There are big fight against to call it rodina or manželství. This is the Czech term for typical family. Yeah. They do not. I mean, there is a political will to recognize the same rights, but there is no political will for the same title. But now I am a member of this ECRE. This is European Commission Against Racism and Intolerance, and so this is much broader. This is based on the European Convention, much broader competence, and one of the most now important issue are the position or situation of sexual minorities in Europe, and because I'm just beginner in this area, honestly, but my main concern or main knowledge till now is that this is very sensitive because it's so different in Czech Republic, Germany, or Georgia, So it's so difficult to set some universal principle for all these member states. I mean, member states of Council of Europe. So, but I'm not lost, and I don't know what was your exact question. Oh yeah. So this is a big concern of Council of Europe, for example. But I mean, it depends on dealing with concrete situation, as well as religious minority, for example.
Can you specify? So there is the recognition of same-sex unions in the Czech Republic?
Yes.
Mm-hmm.
We have like registered partnership. It's called.
Registered
Yeah.
partnership.
Registered partnership. We have.
Registered partnerships, and partners have
Almost equal
rights?
rights, almost equal rights as in marriage, but almost. And now it's a proposal.
So what
to
is
say,
that? What is not covered?
it's not. It's
So
not called
inheritance?
marriage. Inheritance is covered.
Okay.
They have also the
Children?
children.
No, this was the main problem.
Yeah, this is the
The
problem.
adoption
Problem
of
is
children.
The name to call it marriage, and also they're limited for adoption.
Yeah.
And now there is a proposal to amend it to say that the rights will be equal, and I think it's also a question not only political, it's also a question of the Catholic Church to be very much against it.
That's why this is
so
not happening in Poland.
Yeah.
The church is much
And
stronger in Poland.
I mean, there are two biggest questions concerning this minority. First is children. The biggest question was about the adoption of children, because there was a big paradox in Czech law that Czech civil law says that if you are like a single member of sexual minority, you can adopt children. But if you are in this registered partnership, you cannot. But Constitutional Court changed this law, or changed about this law. And the second problem is what my colleague mentioned. This is not only, I would say, Catholic, but the notion in the society, especially now. This is against some political card. It's something like against immigrants.
But you have
so
the
it's
same
same
debate
against
in France, for example. I mean, there's a strong movement against gay
But it's
marriage and the
interesting,
adoption, and there the entire discourse is about filiation. How will you track basically filiation, which is actually a nonsensical argument?
Maybe I can for this question for the other types of minorities. The problem is that there is a difference between the minority protection, which is maybe this traditional, so they call this traditional minorities like national, religious minorities, and for example the sexual minorities are usually treated in anti-discrimination law, which is slightly different, so it's not the same situation legally, and it's very interesting. We now have a project on a definition of so-called new and traditional minorities, trying to influence also the discourse on that. You can see it also as a minority question, but it's for many reasons it's very difficult. But it's very interesting story.
Right,
but this anti-discrimination law is much stronger than the question of protection of minorities. In fact, so that's
And the advisory or the framework convention, the international view is to combine. They would like to cover all, Also immigrants, also sexual minorities and others. They have tendency, because the self-identification, you want or you don't want, you know. So this is their concept, their understanding. And this is so, even, I mean, the gap is even getting deeper and deeper because states are getting even more conservative and more restrictive. So it's like this.
Any more questions?
I have a question. Thank you for this very interesting talk, very complex talk. I have
Thank
to
you.
say. Okay, it was a bit louder. And my question is more, I'm interested into historiographical developments because there is a big issue right now, I think in the EU Parliament, about the recognition of other victims of the Holocaust. And I'm asking this question because the Czech Republic was involved in a lot of, I don't know, histories of displacement of minorities, or, yeah, and so on and so on. So I'm just interested if there is a new development or a new discussion in the Czech Republic about this, and
I don't know if you, I don't think so. You know,
for example,
I mean,
concerning Roma and Sinti
you-
as victims of the Holocaust, if this is
also like Roma victims, and you mean Jews or
yeah.
oh yeah.
So Roma,
Yeah,
Roma,
yeah. I'm sorry. I use this term Roma because we are used to use it, you know. So, but I know it's controversial term too. So I do not know about any like concrete. I mean, in Czech Republic about some concrete situations or negotiation concerning this. But you know, it's this is still. This is still
not new, but I think that I think 6 years ago when there was the renewed discussion about the Holocaust, also within the Central Europe, which was also concentrated on Germany and Austria, on certain issues which were not covered in the 90s. Also the Roma population of the cities were also covered. But the problem is that today's population of Roma in Czech Republic is in fact a population which is from Slovakia or Romania or Hungary after Second World War. So it's not the original Roma population from the interwar period. So they are in fact kind of a new migrant minority. But nevertheless, I think that the Czech Republic then recognized that the original Roma population was the same victim as Jews during the Holocaust. But the problem is how many survivors you can find now. So that there were certain families which were treated in case of restitution of some they were given some money. But it was a very limited because of the scope of the families which really survived.
right.
So I have a question related to this issue of Roma populations that some were traditional minorities because they had been living there for centuries, and some were migrant communities who came after 1989. So same thing in Poland. So is there a distinction in the treatment in the classification of these different Roma groups as Czech minority versus migrant communities?
No, I don't know.
Well, I think that
Because some of them, like in Poland, you have like traditional villages, Roma villages, for example, and they're considered also these are the Polish Roma versus the Romanian Roma.
It's like
And
travelers
they're not-
in Great
There's also
Britain.
a
Yeah.
distinction that's being made between.
this is more in Slovakia than
Yeah.
in Czech Republic. I think that it's also because of what communist regime did with the Roma population, that they try to resettle them and
And
things
unify
like that.
them, and
But I
assimilate.
think it's very good to see it as a social problem, not only a minority problem. And the communist regime was really treated it as a social question, so that was very, very different. But
But in
I-
the
I
education,
think,
for
no,
example,
the
whether they
the
have
education
access
is
to-
disaster, and I mean it affected all the Roma population. I mean, in my opinion, these divisions you mentioned are mostly from the inside of Sinti and Roma population, not from outside. We take them really like a Roma. And this is the influence of the communistic regime to unify and assimilate them. And we take as a Roma even people who are just looking like a Roma because we are sort of xenophobic sort of nation. And also this is a big, huge problem not only with education, but with the adoption of small Roma kids, because it's you cannot even believe that the minister and its regional authorities, they have forms, like exact forms, when they are deciding about some till 3 years small Roma kids. So they decide on their opinion, it's a Roma or half Roma, and this is half Roma and Vietnamese, because now we have a lot of such kids like Vietnam, from half Vietnamese and Roma origin, and they are making such forms. I wrote an analysis for the ministry, so I was really shocked by this. And the social workers are, oh, it's half Roma, this is just quarter Roma. And with this, but you know what's disaster? With these papers, they are going to the they are not able to take any foster care. They are staying for all their till 18 in some institutions, because you know the Czech people. It's also the other side of the story, that the Czech people, I mean, applicants for adoption. I saw also their forms, and they put, we can have ill kids, very ill kids, very, I don't know, but just please not Roma. And when they need to explain, they are, oh, we are from small village, and people would look very bad on us when we have Roma, and we are not able to educate him or her, because you know they are, you know, and also the bad functioning of some human rights organization, because they, based on such situation, they started to issue brochures how to educate small Roma kids, like monkeys, you know. And then these people are even more afraid, oh, I need to read some brochure, how to educate them. You know what I saw? This is, no, we are with Romania, the only state with a huge number of small kids till 3 in the institution, and this is almost Roma, like 80% Roma, because they are not able to be in foster care. And then the education, even after inclusion, you know, the society and also the policymaker, there are strong movement, very populistic, against inclusion. You know, because you know our president says it's like in a highway. You have, I cannot even repeat this. You have better and quicker, faster car, and this slow car. So it's not good to mix them, you know, because then you stop the traffic. So, and this is just the words of our president, and this is maybe the opinion of mainstream of population now.
But to be fair, I said that this was also the development after the decisions against Czech Republic because of the Court of Human Rights. So the lists were prepared just for protection, you know. So this is a kind of a paradox, that then you are criticized, that you are trying to take also some measures against the discrimination, because then the Czech Republic was said that there were only this special classes for Roma kids. So they were trying to ensure that it won't be the case, you know. So and so it's even more complicated. You know, sometimes you put such lists for different reasons. So it's not because of discrimination.
Well, thank you very much for the lecture, and there will be other occasions